most recently married person will pray for us. What is right now?
Let us pray. Righteous and eternal Father, we give you thanks for this a day that was not guaranteed, but because of your grace and mercy, you've spared us to see it. As we gather here to discuss the business of the nation, we pray that you will be with us and you will guide us to think logically and to operate with goodwill towards everyone. In Jesus' name.
Thank you. Thank you. I see that the association with your wife is already rubbing off well. All right. In terms of apologies for absence, I would indicate that, not absence, but I did receive indication from 3 members about possible lateness, which is actually why the time was adjusted to try to accommodate them as much as possible. But, well, here are 2 walking in as we speak. Welcome to all members. Any other apologies for absence?
It's not an apology for absence, but I have no difficulty with today, but I think we also need to be very careful. Once we have sent out the notice for meeting, giving date and time, how we change it, because when we change it to facilitate someone who can't make it, it also means that you have not spoken to the rest of us and you do not know how the rest of our day has been affected because of that.
I'm got it. All right. So, if there are no further apologies for absence, then we'll proceed. Today, of course, is an opportunity for us to set the parameters around the operation of the committee. And so I'll give some remarks that hopefully will be beneficial not just to us, but to the future operation and execution of our mandate. Thereafter, we'll go into the minutes, matters arising from the minutes, the matters that have been referred to us in terms of review of the reports, and then any other business. Now, as chairman, I consider it necessary for us at the outset to place on the record a clear statement of the purpose, the mandate, and the approach of the Integrity Oversight Committee, Integrity Commission Oversight Committee. This statement, of course, is not just intended merely for today's sitting. It's intended to assist the work of the committee in the months and the years ahead, and to provide a principled framework for those who may sit in this house and at this table in the future. The work before us, members, is important because it concerns the integrity of public life, the authority of our parliament, the independence of a major anti-corruption institution, and the rights and reputations of persons who may come within that institution's processes. It therefore requires balance, discipline, and seriousness of purpose. The Integrity Commission is a product of a deliberate national decision taken in the Integrity Commission Act 2017 to bring together under one roof 3 bodies that had worked separately: the Office of the Contractor General, the Commission for the Prevention of Corruption, and the former Integrity Commission, which was the institution that received the declarations of members of this House. Parliament resolved that the fight against corruption should be concentrated into this one very powerful commission of Parliament brought into operation by this government in 2018. So we must be candid, however, about the impact of what this fusion created. We did not merely rename the Contractor General, which is what is said by many, to the work of contract monitoring and statutory declarations. Parliament added a Director of Investigation, and the decisive point was the addition of a Director of Corruption Prosecution. So for the first time, the same institutional family that investigates could now also prosecute. That is a great power. And this committee begins from a settled conviction that great power, lawfully conferred, demands proportionate accountability. The framers understood this. In the very schedule that gave the commission its shape, they amended the standing orders of this House to create the body that I now chair and that we now sit as members. Oversight was built in from day one. It was central, not optional. This commission, in its capacity, has reviewed the declaration of legislators and public officials. It monitors government contracts and investigates, and where warranted, prosecutes suspected corruption. The government has matched the ambition of 2017 with the resources. So where the predecessors, the Office of the Contractor General operated on a fraction of today's provision, which is 295 million, approximately 295.8 million for the 2017-2018 fiscal. The allocation to the Commission since its inception has grown substantially from approximately 374 million for the 2018-29 financial year to 1.99 billion today. The budget allocation for the Integrity Commission has increased by 432.47% from its allocation to the current fiscal year. I recite this not to boast of what the government has done, but as a premise as we launch out in our oversight. When a nation invests heavily, it acquires the right to ask what the investment has achieved. And each member has to have that central in your determinations. The measure then of this commission cannot be activity alone. It must be impact. The question is not whether the commission is busy, but whether the its work is lawful, is it fair, is it effective, and faithful to the purposes for which Parliament created it. A person may be employed from 9 to 5, present every single hour, and still achieve very little. Presence is not performance. This committee will not be satisfied by how many files were opened or how many statements were issued. We will ask, and we must ask, harder questions. Were the objects of the act met? Was corruption prevented, detected, and where proven, properly brought to justice? That is the only measure that matters to the people who pay for this work. So we are at a very important moment in our history, members. We establish commissions, and having established them, we must hold them to a standard. And this committee intends to do exactly that. That is the balance that we must strike to fulfill our mandate. Neither the timidity that lets a powerful body drift, nor the hostility that would cripple it, but rather the steady discipline of a parliament that expects results and insists upon them. So the first thing we will examine is whether the commission acts within the powers the law has given it. Every public body is a creature of its statute. It may do what the law empowers and no more. When it acts within its powers, it acts what we call in law intra vires. When it acts outside of those powers, it is ultra vires. And its actions, however well intentioned, are without legal foundation. So we must, members, ask of the commission's procedures, was whatever the action is, one which the act authorizes, taken in the manner that the act prescribes, reasonable on the material before it? Was it involved or engaged with due process? Has due process been observed towards those affected? And when we review a report, for instance, an annual report, or a report on statutory declarations, or an investigation report, we shouldn't merely receive it. We must test it to see whether the correct procedure was followed, whether the findings are supported by the evidence, whether the conclusions are one that the law permits. There are settled principles that will guide us. The principle that no one should be a judge in their own cause underscores Parliament's responsibility to provide vigilant oversight of anybody that exercises particularly both investigative and prosecutorial powers. That authority and the answerability are inseparable. The Commission is, and you can check it by Section 5(4) of its own Act, ultimately accountable to Parliament for the performance of its functions. Our oversight is the fulfillment then of its statutory design. It's not to be seen as an intrusion upon it, and I make that case particularly for those in the public that are listening. That fairness must be seen to be done, and that we must respect the boundary of our own powers here as an oversight commission, as strictly as we ask the commission to respect its own. So this committee is a reviewing and reporting body, not a court of appeal. So we do not retry investigations, substitute our judgment for the commission's finding, or direct it, for instance, in the independent exercise of its functions, which Section 13 protects. We hold the mirror. We do not seize the pen. When the commission publishes a report, it enters the public mind with full authority of the state. So if it names a person, that person is, quite often in the eyes of many, marked. That is the reality. Here is the danger that must then be spoken aloud. If a report is published and no one examines it, the person named is in effect, Member Samuda, indicted in the court of public opinion by many persons, without trial, without any appeal, and often without any recourse. The publication can unfortunately become punishment. So a finding that no one is permitted to scrutinize cannot be seen as accountability. That is condemnation without trial. So for us as members, scrutiny is protection, not of the powerful from accountability, but of every citizen from the error wearing the robes of authority. Where a case is sound, scrutiny by us as oversight will confirm, and it will allow that case to stand stronger. Where it is not, scrutiny is literally the only thing standing between an unproven allegation and an irreversible injury to a name. And let the country be clear on whom this concerns. The gaze falls most often on politicians, but the commission's reach is far wider. Permanent secretary, public servant, medical officer, contractor, the declarant. Every one of them passes through this regime. Everyone is entitled to the same fairness. A standard that protects only the prominent is no standard at all. It must protect all. So let me be equally plain about what the committee is not. It doesn't sit to chastise the officers of the commission or to ridicule honest error. To examine the procedures of a powerful body is not an attack on that body. It is the ordinary discipline by which standards are kept. A surgeon submits to review of the operation, not because the profession is under attack, but because lives depend on the maintenance of a standard. The fault we guard against is not zeal. We want a commission that pursues corruption without fear. The fault is acting beyond power, advancing a matter that the evidence does not support, or by a procedure that the law does not permit. Zeal within the law is a virtue. Zeal beyond the law is dangerous. More so when the body wielding it can both investigate and prosecute. So this committee is committed to a strong integrity commission. Everything I have said proceeds from that commitment, not against it. So we will criticize where criticism is due and assess the processes for one reason, that the commission, 5 years hence, should be a vastly better institution than the one that we oversee today. That is our reality. But we have before us examples in which reputations were disparaged and lives gravely affected, with nothing to show at the end and no recourse for the persons who have been harmed. That cannot be the pattern of a mature authority. There's also a stewardship of the public purse in this. So we will have to ensure, members, that the commission does not expend the people's resources to amplify, in the arena of law, matters that are not substantive. The matters must be more than just reports or allegations. Public money spent prosecuting the unprovable is public money taken from prosecuting things that could be proved. So I must name one specific risk. There is a real danger that the standard applied at investigation may fall below the standard the law demands at prosecution. And that is something which, as members, we have to contend with. Any persistent gap, whenever you see those patterns between the two, it is a glaring warning, Member Chuck, that something in the conduct of the investigation is not aligned with the standard that must eventually be met. And a matter built to the lower standard will fail. It will fail in law. And unfortunately, Member Marks, it will fail, but only after a reputation has already been spent. This danger is graver, I must say, now more than ever, precisely because the commission holds prosecutorial power, members. Its predecessor did not. And this is a matter that was discussed heavily. This committee will keep that dichotomy under close and continuing review. It is perhaps the most important thing that we can watch on behalf of the citizens of Jamaica. So this committee, members, considers it important to state that no citizen, and this is based on commentary in the public domain, no citizen should ever feel that resorting to the courts is itself an act inconsistent with the public interest. The rule of law requires that statutory authorities discharge their mandates robustly, yes, but it equally requires that those affected by the exercise of public power remain free to invoke the jurisdiction of the courts in good faith, without fear that doing so will be viewed as frustrating the work of the state. That cannot stand. The constitutional balance lies not in elevating one institution above another, but in ensuring that every institution performs its proper constitutional role, respecting the powers and responsibilities of the others in service of the people of Jamaica. The framework that we have inherited is not perfect. Could never be. The Act stands in need of further reform, and this committee says so openly. On the boundary of confidentiality, the sequencing of reports, the alignment of investigative and prosecutorial standards, all of those matters, there is need to improve. And the moment that we think that we have it all done, we have a problem. In the last parliamentary year, we had a joint select committee that began a review of the Act, and I'm advised its deliberations will resume shortly, and we take note of that from the Oversight Committee and encourage that it happens as quickly as possible. We regard that review as a natural partner to the work that we have to do here, and we will feed our findings into it. So members, I say so that whatever it is that we acknowledge or identify as issues with the Act, we also feel free to pass that over so it can support that process. Wherever oversight reveals that the law itself obstructs good administration, which we will see, the remedy is not to strain the law, to stretch the law, but rather to make the amendments. So we operate under the Integrity Commission Act 2017, and all members should have that act either printed or on your devices. We operate also under the standing orders of the House, and with regard to the corruption prevention framework, the Act is consolidated. Our powers to send for persons, to send for papers and records, and to examine witnesses are real. We have that ability to do so. And it's given force by the several pieces of legislation and authority that I have referred to, by the Powers and Privileges Act as well, grounded in Section 48 of the Constitution. What matters is the spirit in which we use this authority. So I would refocus the conversation of the nation away from what is being done and toward what we seek to achieve, what is the outcome that we are seeking and defining. A public life in which corruption is genuinely prevented and detected. That's what we want. In which the guilty are proven guilty by fair process and the innocent are spared the punishment of an untested allegation, and which a powerful commission is matched at every step by a parliament and a people who hold it to standard. In carrying out its mandate, we, as the Oversight Committee, should be guided by a set of principles. And I've identified 5 standards that can assist us in our deliberations: lawfulness, fairness, timeliness, effectiveness, and public value. I'll articulate them for the benefit of members. First, as chair, I believe it is essential that we ask whether the Commission's actions are, firstly, authorized by law. Every public body is the creature of its statute. It must act within the powers Parliament has conferred and in the manner the law requires. So, where an act is within power, again, intra-virus. Where it exceeds that power, it is ultra-virus. So these are not technical expressions reserved for only lawyers. We now here in this committee must see these intra and ultra-virus concepts as safeguards of lawful public administration. Secondly, committee, we must then ask whether due process has been observed in the matters that we are going to be examining. The fight against corruption is not advanced by procedures that are unclear, unfair, unreasonable, or inconsistent with law. It is advanced when investigations are thorough, evidence is carefully assessed, where the affected persons are treated fairly, and conclusions are properly reasoned, and recommendations are grounded in the statutory mandate. Thirdly, we will ask whether the Commission's work is timely. Delay can undermine accountability. Delay can also impose real burdens on the persons that are under inquiry. A system that takes too long to resolve very serious matters, in my view, risks weakening public confidence, regardless of whatever the outcome is. And we have a mandate to also protect the confidence of this institution. We all want a strong Integrity Commission. Fourthly, we will ask whether the Commission's procedures are effective. And that includes, members, your examination of whether its systems, the case management practices, the reporting formats, the confidentiality protocols, whatever the processes are that they utilize in investigation and prosecutorial arrangements, are those things fit for purpose? Are they achieving the outcome that we seek? Fifthly, we must ask whether the public value of the Commission's work is being realized. In everything that is happening, public money should support substantive anti-corruption outcomes. It must be that if we're going to expend, then there must be stronger governance, better prevention, must be better investigations, appropriate prosecutions, and ultimately we want the country, the entire nation, to feel confident in the work that's being done by the Integrity Commission. So, as I close, a complete examination of a report submitted by the Commission has to be, for us, more than receiving it as referred and simply acknowledging that we've received the report. Whether the report concerns statutory declarations as the ones you would have received in your emails, and a large portion are focused on statutory declarations, whether it is an annual report, and we note is it the 8th or 6th? 8th annual report that is on the website now, 8th, yes? Or is it 6th? Well, the most recent annual report, I think it's 6th. Yes, that is available. Whether it is a special report or an investigation report, the committee must consider what the report says. We have to dive into that, what it recommends, what procedures produced this report, and whether any issue of institutional performance, effectiveness, timeliness, resource use, confidentiality, due process, or legislative reform arises. What are the issues that we need to contend with here as the Oversight Committee? 8th. The committee may ask whether the reasoning is clear, whether the procedures appear consistent again with the Act, whether the findings disclosed in the report are supported by the material that is presented in the report, whether the recommendations that are made are practical, are lawful, are sensible, whether the report identifies matters requiring Parliament's attention. That is the work of oversight. So we have to, as the Oversight Committee, be attentive to the relationship also, very important, between investigation and prosecution. The difference between prosecution and persecution is not the seriousness of an allegation. It is the discipline of the process. Prosecution is evidence-led, law-bound, and fair. Persecution is what justice becomes when power outruns proof, process, or any legal authority. And as an oversight committee, we must guard slavishly against a commission that has the potential to persecute and ensure that whatever is put before us meets the tenets of prosecution. This observation is not made, let me make it clear, because I know that many are listening and will be recording and repeating. It's not made as an accusation against the Commission. It is it's a principle that must guide all public authorities that hold investigative, much less investigative and prosecutorial power. Where an institution has both investigative and prosecutorial functions within its statutory architecture, the standard of care, that standard must be higher. The public interest is not served by matters being advanced beyond what the evidence and law can properly sustain. Nor is it served if strong cases are weakened by delay, by error, or by lack of clarity. So we have to hold those things into our contention and mind when deliberating on matters of importance that have been referred to us. A strong commission, therefore, must be fearless, and we will be so, disciplined. Zeal within the law, as has always been said, is a virtue. Power exercised beyond the law is a danger. And this committee will support the former and guard against the latter. Make that be very clear. At the same time, we will effectively remain within our own mandate. It does not examine a report in order to redecide the individual matter. We won't be doing that. We'll examine reports in order to review institutional performance and to report to Parliament our findings. A recommendation that procedures be strengthened, delays reduced, reporting clarified, resources addressed, or the legislation, where necessary, amended. That falls within our role. A direction that the Commission reach a different outcome in a particular case, that does not fall within our role, and we won't be going down that road. We built this Commission with the nation's trust, and we will hold it to the nation's standard. That is the whole of our charge. That is a balance that we intend to strike, and the work that this committee now begins. That said, members, you would have within your remit a number of documents that have been sent to you. The minutes from the last meeting of March 12, 2026. I would ask that we take a look on those minutes if you have not done so before. Yes, ma'am.
Mr. Chair, I welcomed your opening remarks, and I thought them very timely. I noticed we are moving to matters at hand without an opportunity to actually say. I found some of what you said very helpful, but there are some things in what you said that concerns me greatly.
Let me assist you, because the welcoming and opening remarks perhaps is not the point in our agenda in which you would have the opportunity to refer to those issues, but you will get that opportunity.
I would like to be guided, because your remarks were general remarks and not for individual cases, and therefore it would be good to see at what point on the agenda that is before us that those general comments that you made at the beginning, certainly some of which I found troubling, and some glaring omissions that I was concerned about, would then be raised.
That's agenda 8, any other business. Because what we have now is, we're at 4, welcome and opening remarks by the chair. 5 is reading and confirmation of the minutes of the meeting held on March 12, 26, which is where we would invite the minutes. 6 is matters arising from the minutes. 7, review of the reports of the Integrity Commission. And 8, any other business that you want to discuss. And at that point, I welcome whatever remarks you want to have at that time. All right? You're not on mic. Yes. Yes. So I would move to...
No. I am now on mic, unless you're making a ruling that I should not be on mic.
I'm making a ruling that we can move ahead with the
No,
agenda.
I'm simply saying to you, Mr. Chair,
if you're repeating what you have said,
that at any other business I would like to be called upon.
There's no need to say that, because I've already committed to that, and there's no difficulty. This is not the back and forth in Parliament. We're one committee. And I intend to hold us to account as one committee, not separate members. All right, so let's move to...
Mr. Chairman, I think in light of your opening comments, though, members should be asked if they want to comment. The reason for this is that I thought you've made some good points, but there are other points which also can be made. The first point your comments really, no, I just want to say, I thought that the IC would be present today.
Member Chop.
Yes.
Let me say this.
Yes.
Permit me to move through the agenda. We will have an opportunity to ventilate all of these issues. There is nothing that says that it has to happen instantaneously. All I'm asking is that we follow the agenda. There's a purpose to its order. And as chair, I'm going to ask members to just allow that we go through very quickly, and we'll have an opportunity to say
Chairman,
fully.
Welcome and opening remarks should be not only for the chairman, but for everyone.
You're welcoming me after I've welcomed you?
No, you're welcome, and I welcome to be here at the meeting. And
no, well, you have it wrong.
But
the opening remarks are not for you. The opening remarks are within the remit of me as chair. You have a problem, member. Go ahead.
Mine is procedural too, yes. Because I just want to know where I will be allowed to raise, not just on what you said, but I also have some procedural questions that I'd like to ask about how the committee operates. So I want to know where on the agenda that would be. So, and I would say I'm guided by you, but given how extensive your opening remarks were, in fact, there were a dissertation, right, on the work of this committee, I would support Member Chuck in saying that given that extensive dialogue, it would be appropriate for members to comment.
So I thank you for your submission. And again, I note that if you read through the minutes, you recall that at the last instance, there was an opinion that was requested. The matters arising from the minutes would also be another opportunity, if you have any issue relating to procedure, for us to address that kind of matter. Member Campbell.
Thank you, Chair. I wanted to understand if the ruling is that something that is mentioned in opening remarks should be addressed under AOB, because my understanding of AOB is for items that did not arise in the other parts of the agenda, that it comes at the end as almost a safety net now, that whatever you would have missed, you can now introduce it as any other business that wasn't discussed. I did not get the impression that AOB is for something that was discussed already. I certainly did not have that impression, so I'm asking for your guidance.
Yeah. All right, so the guidance is simple. We're trying to go through the agenda, get these matters treated with, and then we'll have full opportunity to go through all the different remarks. A lot of, just permit me to finish. A lot of the matters that relate to procedure will also intermingle with the matters arising from the minutes. Because a lot of what I said was based also on our last meeting, where we called for the parameters within which this body will operate. So instead of repeating, what I'm asking members to do is just for us to read and confirm the minutes, and then most of the matters that you have an issue with that will be procedural in relation to what this committee's function is are actually going to arise at 6. So we don't have a difficulty in relation to whether or not you should be heard. All I'm asking is for us to move to 5, read and confirm the minutes, go to 6, and we can have all the time we want to ventilate everything. Not all the time, but we can ventilate it at that time, yes. No, I hear you. You're talking about any other business. And I'm saying to you that, one, matters relating to what I discussed that have to do with the function of the committee can be and are best discussed at 6. Any other matters, which I don't know what members have in their mind, can be discussed at 8.
Please. I'm saying to you, I'm not limiting my question to this particular instance. I'm looking at a precedence that is being established. I am trying to get the understanding if what you're saying, because there could be a next meeting when something that is mentioned in opening remarks is not addressed in the minutes and therefore would not be properly placed as a matter arising from the minutes.
And in that regard,
and it would not be properly placed as AOB,
yes,
because it would not be any other business, because that business would have been dealt with already.
Yes.
So I'm seeking to understand how is it that a matter that is placed squarely before us cannot be taken until we get to item 8, where we are discussing other business.
It can be taken. It can be taken. But as chair, I'm saying to you, instead of us repeating, it is the same substantive matter that we're going to treat with in the minutes.
Chairman, you put these issues on the floor, you know. You
Yes.
are the person that placed them on the floor. And so members now want to comment on the very issues that you have placed on the floor.
Yes.
So
And
why
you're
would
going
you deny them that privilege?
Nobody is denying. You, again, what you're doing is you are formulating your own opinion as to what I
But I
ultimately
can't
am seeking
formulate
to
the next
achieve.
opinion, only mine.
And no, because you're saying, because what you're saying, member, is that I am seeking to deny. And I'm saying to you categorically, we don't have to go back and forth on this. It's a simple procedural matter. All I'm saying to members is let us read and confirm the minutes, because what is in the minutes is inextricably connected to what I have discussed. Read and confirm the minutes so we don't have to end up repeating ourselves. Can we read and confirm the minutes, please?
I note that the minutes, in the minutes, I am absent without apology. And I can't recall getting the invitation for this meeting or any paper, any knowledge of a meeting on March 12th.
Well,
I've been
in that regard,
asked,
I'll ask that the
yes.
Secretariat note that and the necessary adjustment be made.
Yes. So,
We note it, member, and we'll
Thank
make
you.
necessary adjustment. All right, in that being said, Member Campbell will confirm the minutes, and seconded by Minister Samuda. Thank you.
Where do we make any amendments? In which item here covers if there is a correction to the minutes?
You do it now.
No, I'm just, based on the question or the point that was made, I'm just saying which item here would capture if there is a correction to the minutes?
Which
Is it
will be
item
now.
5 that would
Reading
do
and
it?
confirmation of the minutes.
So in the future, do you want to expand this?
It is well understood that any amendments to minutes are articulated by members who are at the meeting, and those amendments will be
there are
accepted.
some agendas that you have reading of the minutes, then you have confirmation or whatever it is that you would want to make amendments to the minutes.
So you
And
want to
then you have matters arising. So I'm just asking because
So are you just for
I'm
clarity?
not talking about this meeting. I'm just talking about how we operate. Because I'm saying at another time it could be that somebody had a correction to what was said in the minutes, and I'm just asking which item here on the agenda would accommodate it. That's what I'm asking.
So to be clear, the item that would accommodate it is the same item 5.
The way the process. So normally I think would go through page 1, page 2, page 3 to make sure that it's agreed. And the amendments or corrections or clarifications are noted as we go along. And then, it is then confirmed after the amendments have been made.
All right, so you want to go page by page?
I think it would be a good idea.
Not a
Mr.
difficulty.
Chairman. Okay.
So we'll rescind the confirmation that was just accepted by Member Campbell and Member Samuda, and ask members if there are any issues with page 1 of the minutes of the meeting of the Integrated Commission Oversight Committee Thursday, March 12, 2026, save and accept for the amendment or the matter that was noted by Minister Marks in relation to her absence without apology. Is there any other issue on page 1?
I would encourage the committee not to have meetings on days during the budget presentations, particularly for members who have to participate in the debate. Okay?
All right. Any issue with page 1? I'll take that as accepted. Any issue with page 2? Minister Marks, any issue with page 2? Any issue? Member Campbell, page 3? I'll take that as accepted. And page 4. Yes? All right. All separate pages having been intricately examined by members and accepted as there being no need for any further amendment under the law as constituted and the authority given to us in this House of Parliament as we serve the people of Jamaica for all 14 parishes. We then say that, or we ask, again, I'll ask Member Campbell, can we confirm the minutes, your name? Yes, and seconded by Member Samula. Thank you, members. All right. So we're now at matters arising from the minutes, and having gone through the minutes, members would know that the item 4 would have generally been arising from issues which we discussed at the last instance, which relate to what exactly this commission is to do, what our functions are, what are the guardrails, what are the parameters. So, to you members, at item 6, any matters arising from the minutes? Minister?
Well, all right, I had my mic on. Two questions. Given that we are examining reports from the Integrity Commission, and I have questions about reports, as a procedural matter, shouldn't there be, and I think Minister Chuck was going there, a representative from the Commission at these meetings? So, for example, I have questions on the annual report, which nobody here would be qualified to answer. And so, one is, I believe, as a matter of course, if you're examining reports, there should be a representative from the Commission who is invited and participates. That's one issue. Okay, I have another one I want to come to, but I'll allow senior counsel to
Chairman,
intervene.
it is always my understanding, and even if it has not been done consistently, that when the Oversight Committee meets, we should have representative from the IC. I don't think it's appropriate for us here to be just discussing in a vacuum without them not being present. So that I just want to reassert that once reports are tabled in Parliament, maybe 2 weeks maximum, that we should we should have a sit to consider the report. But in considering the report, we should invite the IC to be here unless we have nothing to ask, as the case may be. But as Member Robbins is saying, he has certain questions to ask which none of us can answer. And I would say, in going forward, Chairman, apart from what you have said in your opening remarks, I think we should ask the IC to comment on your opening remarks. And I also have a number of remarks to make on any other business, which I would also like the IC to comment on too. Okay? So we can move forward. Sorry to interrupt, Member.
No, I'll always allow senior counsel to amplify my point.
I hope that spirit of togetherness continues throughout
It always
exists.
It always exists. Now, my second question. And
you want me to respond to one?
Huh?
I just want to add to one.
Okay.
To indicate that I too have asked the same question. My understanding is that we as a committee need to meet formally and then to make that request. And going forward, then that will be the circumstances under which we operate. So it was intended, but we have to have this meeting first.
My second question now relates to the ability of this committee to discuss matters related to the process that the Integrity Commission may have followed in a particular case where the subject of the investigation has initiated court action. So while I may not want to comment on the content of the report, which the subject is the report on the subject, I have questions on the process that the Integrity Commission may have followed. And I want clarity as to whether we can raise questions, have a discussion about the process that the Integrity Commission may have followed, where a subject has taken court action in relation to the report.
I think that's a very, very important matter to raise. The matter of whether issues that are sub judice fall within our remit. And it is a matter that we'll have to treat with case by case as well. Because it also will be determined, in my understanding, of what the substance of the court matter is, right? And also how the report has been constituted. But it's a matter of which we can also seek some specific guidance from counsel that supports the committee, and I will do so.
Horizon. Thank you, Chair. So I do want to thank Committee Clerk and Legislative Council for the memorandum which guides us based on my question or request in last committee meeting. Just two points of clarity arising from the minutes and, of course, the actual memorandum. This confirms my recollection from the debates of 2017 and confirms my comments then that a challenge could arise from simply establishing this committee through the standing orders as opposed to clearly defining in the Act how the Oversight Committee would function. On the subject of recommendations, well, first, before I come to the recommendations, which is in the memo, I believe also your agenda going forward will have to have a 7A and B, which will deal with the operations of the Commission in line with what the standing orders allow us to do, which is to also look at their specific operations. Because as you mentioned in your opening, it's a sizable budget item, and operations cannot happen in a vacuum without being interrogated here as well.
To be clear, remember, you're asking for the agenda going forward to have, on the review of reports of the Integrity Commission, subsection.
That would be A, and review of operations of the Commission as B, which the standing orders allow for, but not covered in the agenda.
In the context of the reports?
In the context
or just generally?
Generally. My understanding and reading the memorandum that is a part of the role of the committee, which is not on the agenda for today. So I believe going forward, it would need to be covered, because the operations or procedures followed in relation to any investigation or assessment from the Commission can't be taken in a vacuum, also outside of their administrative operations and what guides them. So I think that needs to be done. And just on the subject of recommendations, which forms a part of the memorandum associated with the item under the minutes, I'm not totally clear whether recommendations have to come from a settled matter of the committee, or recommendations through your office can be forwarded to who, in the form that it is allowed, from individual members as their individual recommendation. That isn't settled for me here. So, for instance, if I wanted to make 2 recommendations to the Joint Select Committee related to their work, having looked at the operations of the organization or the substance of any report, if I have a differing view from perhaps Member Robinson, would my view be able to be channeled through you to the Joint Select Committee for consideration, or would it have to be a settled matter, either by majority or consensus from the committee? That I wanted further clarity on.
Thank you, Member. Just to indicate, not for me to respond to both matters, but in relation to the first matter that you raised regarding the functions or reviewing the operation of the IC, under Standing Order 73D, subsection A, I believe that is supported and understood, but it can be delineated separately as an item. I have no difficulty with that. I don't think members have any difficulty with that. As it relates to the second item, I'll leave that to Council and the team that advises and supports us to get back to us on that.
Pleasant afternoon, Chairman. Pleasant afternoon, members. With regard to the last question that was asked about a dissenting view, that is governed under Standing Order 80 that deals with reports from select committees, and in particular, Standing Order 80 subsection 4C, which speaks to the fact that any member dissenting from the report of the majority of the committee may, by leave of the committee, put in a concise written statement of his reasons for such dissent, and such statement shall be appended to the report. So if it is that you have a recommendation or a view that is not accepted by the majority and not contemplated in the majority report, that being the report that all of the members would deliberate on, you could have a minority statement or a dissenting report being attached to the majority report with the leave of the committee. I would recommend then that if such an instance should arise, that you seek the leave of the committee when the committee is actually deliberating and voting on the majority report. I trust that that helps. No problem.
1 second for me, members. I want to thank Council for the clarity. I want to just bring the attention of the committee members to clause 80, section 4, subsection C of the Standing Orders of the House of Representatives that says any member dissenting from the report of a majority of the committee may, by leave of the committee, put in a concise written statement of his reasons for such dissent, and such statement shall be appended to the report and would properly be defined not as a minority report, I believe, but as a statement of dissent. Any other matters arising? Member Brownberg? You're any other business? No, we don't reach there yet. I'm saying we are. So you was in trouble, people. Let's leave things alone. All right. If there are no other matters arising from the minutes, what I will do is move swiftly to the reports. But I want to make a reference to these reports within context. Just to you want me to finish my sentence and then you intervene, Minister Chuck? Yeah. I'm going to move you from beside Member Campbell. I think there's a yeah. Let's stick to the committee at hand. Just to indicate, some members would have had the memorandum relating to the role and the functions. It's important. I also want to note that there is another specific request that was made by Member Samuda that we are compiling, completing, and at the next instance will be delivered to the committee, which is specific to the matter that you raised in relation to a report at the last instance. As we move to 7 on the agenda, as is noted, we don't have members of the IC here with us. It is noted that the committee has made the request that going forward, the committee has the sufficient support in terms of whatever resource officers from the Integrity Commission or any other body that is relevant are here to respond to whatever questions could be raised or have been raised at the previous meeting. Nevertheless, I just wanted to give some context of what the nature of the reports are that have been referred to us. It has been sent to members, but I doubt that members have been able to go through based on the voluminous nature of those reports. Yes, Member Marks.
Sorry, Mr. Chairman. There's one other matter in the minutes because I'd missed the first meeting, and
You're going back to
yeah.
6?
Yes.
So let's just
sorry. Yeah, just.
I think we have to officially ask for recommittal, do we? So we ask members for a recommittal to to item 6. Aye.
Yes. Sorry, Mr. Chair. I just wanted clarification. On page 2, we looked at the functions of this committee, but I know that it's not included that we'd also look at the reform or any reform or amendment to the Integrity Commission Act. Is that the other committee, the standing? Okay, all right.
That's a joint select committee. However, what I did note and indicate is that members here are encouraged as we start to examine administrative and procedural issues, that if there are matters arising that would relate to substantive suggestions to that committee, that those will be put through to assist them in the deliberations of whatever amendments going forward.
Thank you.
All right.
Thank you, Mr. Chair.
All right, so we return to item 7. As I was saying, so clearly we won't be going comprehensively into any of the matters or examining matters in detail, but I do want, for the benefit of the committee, to at least give a categorization that will assist. So has this been sent to committee members? All right, so the reports that you have before us are 64 in number, and majority of them, 57 to be exact, relate to statutory declaration non-compliance, failure to file. And that's the dominant stream in terms of the matters that are before us for our consideration. We also have what I've defined as 2 other categories of matters. Substantive investigations, we have 5 of those, of which you know those matters. And in terms of annual institutional performance reports, as we had noted before, we have 2 of those before us to address. Some of them, I assume, we'll be able to summarily deal with because of the nature of those matters. But there are questions that I would encourage members to ask themselves when going through the reports. The statutory declaration, for instance, we'd want to find out whether, are we satisfied that the Commission is applying a consistent approach to statutory declaration, non-compliance? Are we satisfied? These are matters you would want to consider in terms. No, I'm just giving you hypotheticals. It's not relating to any matter. It's just a matter of some context to how we would want to examine and dissect the matters before us. And there are a lot of statutory declaration, non-compliance matters. So we would want to ask, for instance, the committee, if they are here, the commission, to give us some guidance, explain to us the various processes, what's the escalation of the process before a matter becomes referred, for instance, to the Director of Corruption Prosecution. These are things you want to find out. Do the repeated non-filings point to weakness in the public sector? I don't know. Awareness, do we need to raise awareness? Is there a need for us to say or suggest that there be more campaigns around awareness, around reminders at ministries, at agencies, at departments? Because the goal is not to persecute. The goal is to make sure that we are preventing and detecting corruption. And there may be genuine errors that we can avoid by ensuring that the information is effectively out there on what needs to be done. There are some persons who have genuine situations. And so should the committee recommend that public bodies strengthen their internal compliance systems and awareness around these issues? These are some of the matters that the committee is encouraged to ask. Now, in terms of the declaration, verification, and integrity breaches, which are more substantive, we have to dive into those reports to look on the operational gaps in the regimes. We have to look on the various findings. What do those findings suggest in terms of isolated breaches or recurring weaknesses in the processes across government? And for the various matters, I won't go into the detail of what members might want to interrogate, but I just encourage you that as you examine the matters, look to see whether you are satisfied that our commission, the Integrity Commission, is discharging its statutory functions under the Act. Is that being done? And if so, we must ensure that it is upheld. If not, we must ensure that matters are addressed. Importantly, again, we are definitively not here sitting to retry the reports. Our task when it comes on to addressing these matters is to determine whether, taken together, they show that the Integrity Commission is functioning effectively and within the remit of the law, and where the reports disclose recurring breaches or systemic weaknesses or whatever the follow-up actions are that are required. As a committee, we should look on that and note that, again, you have 90% or more than 90% of the 64 reports before us concerning a single unfiled form. Can this be remedied? This is something that can be improved in terms of how we treat with the matters. So we ask then that council and the secretariat, is that the right nomenclature? Secretariat, committee, clerk, note the request of the members in relation to the IC, and I'll expand that if there's no objection to whatever institution, body or so that is relevant, and to provide members with notice of who is intended to be called, so that members are not surprised by the attendance and that members can have an opportunity to prepare accordingly. Minister Sumuda.
Thank you, Chair. Just to note that the request, as per discussion in matters arising from the minutes, should also include the Commission's or membership of the Commission staff that can address operational matters within the context of the standing orders.
Got it. All right, members. Which side? my apologies. My apologies. I always glance that side.
Thank you very much, Mr. Chair. Mr. Chair, I know that Chairman's privilege would have allowed you to make the comments that you did earlier about some of the issues that we need to ponder as we review the reports. I would like, though, to also say that one is, and you rightly covered, a number of issues to consider on the part of the IC itself. I think, too, that we as members would also need to ponder how we deal with issues of individuals deliberately withholding information from the Commission, and what does that mean? Are there implications for our committee with standards of behavior and so on? And just as important, I was also thinking that in a number of the cases that are failure to file, sometimes individuals have actually paid the fine that is requested of them since the filing of that. It would be important also to know. Also, there seems to be that huge gap that if I refuse to pay, then what? And as I think you had made some, you had alluded to it, if as repeat offenders, for example, then what? Because I believe that these are also some of the things that we see appearing from the cases that are before us. And also, in terms for your class 2, the substantial investigations, I am seeing in a number of the recommendations that the IC itself has made issues that quite frankly point to an absence or breakdown in the management of the entity under review. And I believe that it is unfair to have the IC hamstrung with issues that could have been prevented if the administration of those entities, the management of those entities were to follow the laws. And I believe that we also have to talk about stuff like that and see how we can prevent that or provide some other kind of penalty or other actions that can be taken there. I just wanted to place those on record.
Thank you, Member.
Chair, I wanted to ask if we could make a request of the IC when they're coming. I don't know if they have the information, but at times, I don't know if it happens to others, but it is at times frustrating when you see all of these reports come into the Parliament, failure to file, right? And failure to file. No, failure to file. No, to file. Yes, they didn't submit anything. Most of the reports, 57 I believe of the ones on the list here, are failure to file. Now, I agree with you, Chair, that we do not want to make criminals out of good, innocent citizens. I agree with you. That ought not to be the aim. And I agree as well that clearly there seems to be a need for greater education and awareness. But I wanted to know if the IC has any information that could show us whether or not when we have these cases of failure to file, do they eventually file, and or do they dispose of the issue, or does it result in a substantive investigation? So we could have an idea as to whether the failure is a deliberate mechanism to avoid the scrutiny, or if it was just an innocent mistake or unawareness of the obligation to do so. That's my first point. My second point is in relation to the substantive reports and the perceived damage that you would say it would do to one's reputation, and the procedure that is used to get to that point. But in looking at some information elsewhere, in the annual report, for example, If you analyze it, you'd realize that of the investigations that commenced for illicit enrichment, for example, one has been recommended for charge, one has not been recommended for charge, and 6 have been discontinued. So it would say that only 1 of 8, which is 12.5%, that has been recommended for charge. My issue is that, well, clearly it is the operations of the Integrity Commission is such that if they start the investigation and you provide the information, there are no gaps that they discharge or they dispose of the matter and your name is never called. So clearly that protection is there. The evidence is there to support that. The issue, though, is when somebody fails to provide the information and then comes at the end to say that I'm being unfairly treated when you were asked to provide the information and did not take the opportunity to do so. Because I'm quite sure that the ones that have been disposed of, that those individuals provided the information that caused the commission to be in a position to dispose of the matter. So how we treat with those matters, the obligation to provide the information, I think is a critical matter that we should look at.
Just to respond before Member Dalrymple Filbert. Firstly, as it relates to the first issue that you raised, the nuances of the report as to what exactly the person did that led to the outcome of them being charged or otherwise. The matrix that we put together for you, if you look on it, it has a category, a column of key findings, and it speaks directly to what you said. Even at the first one, it shows that it's not that the person did not file, right? They did file thereafter, but in one of the cases, for instance, did not pay the penalty. And at each case, it's very important as you start to examine all of the matters, you will note each case, even under one category, is unique in its circumstances. So it leads me to the second issue that you raised, where it might be, for some, a reasonable assumption that if you have X amount of matters, some disposed, one advanced, and one not advanced, that the one that has advanced must be then that this person did not provide. And that's not true. No, what I'm saying to you is that it is a... And I'm saying to you, that's what we have to interrogate. So regardless of it being written, our duty is to interrogate the facts, look and examine the findings, and determine if that finding actually is procedurally supported by what the commission has led to. And you will find, I'm telling you, when you start to intricately examine it, that it is not true, it is a fallacy to draw an assumption or a conclusion, as you have said, that because there is one matter that stands out, it therefore means that this person did not follow the procedure. However, what you said is essential, and I think it's the same thing that Member Brown-Burke was saying, that as we address our minds to the activity of the Commission, we should use the opportunity, we must, to say to the nation that we expect, even if it doesn't fall directly in our mandate, because we can't, I mean, we're not here to give specific direction to individual declarants, but we can use the opportunity, and we should. I see no difficulty in members making statements to remind persons of their own responsibility as a citizen, particularly responsibility as public servants and other officials who are part of this process. But again, I caution us. We cannot take an approach of simply seeing on the surface and assuming. That will lead to the wrong outcome for the committee. Yes, Member Dalrymple.
Thank you very much, Chairman. I just want to pause for a moment to congratulate you on your opening remarks, because I think it is important. that we recognize and say to the country that as an oversight committee, we support the Integrity Commission. Our government supports the Integrity Commission. But what we want to do is to prosecute where necessary and not persecute. And in persecution, it's not just the persecution, it is the absolute damage that one does to a person's reputation. And going back to what member from Eastern Westmoreland said, you cannot, and you said it, you cannot assume that simply because information is not provided, you know, it is something that you're hiding or up. Because what it is that happens, it is very often, it can happen, it has happened, where you ask for information. For one reason or the other, you don't recall. There are times where there are persons who might have, for example, I just pull out of the hat, there are properties you pay taxes for, but you're in a company situation where at the end of whenever it is that you are to pay the taxes, it is brought to you and you write down and you pay, the person in the company pays it and you send it off. But that does not say that you remember that 40 years ago your mom gave you a bit of land and you own it and you keep paying taxes for it. But you know, parents come from rural Jamaica, you have it there, you're not doing anything with it, you're paying the taxes because it is yours, but you don't even recall it. Then, so you don't have it on a report, you're asked about that bit of land, you say, but I don't have anything like that. Or an insurance policy that you took out at 19, long before you dreamt you were in politics, and you have it. Sometimes you pay it, sometimes, as a lot of persons that I'm familiar with, the policy lapse because you forget it at 19, 20, 30, not paid. But you never put it on because you don't remember it. You are asked about it. You say, but I don't have that, no insurance policy. You check back and you do. And when in fact, there are two situations that can arise. You don't put it on, and a report comes because they have found it. Once your name gets there and you have not, immediately, the public assumes that it's not even a piece of land out in the country now, that you have something that you have dishonestly and you're trying to hide it, or an insurance policy that you haven't. That is one situation. And immediately, the reality is in this country that once your name appears, there is something dishonest about you, and I think it is not right, to put it very lightly. And the other thing is, what happens when you indicate you have been written to about something, you write and say, I don't remember that, I don't have that. But prior to the report being done or you being charged, you're brought into a meeting with the Integrity Commission and you have recognized. You ever know when you sit and you forget, recently the bank in Falmouth wrote me about a safety deposit box. I said, I don't have one. I've never had one with NCB. They said, oh yes, you have. When I find out I had it for 35 years. But listen, goes, I said, I didn't remember that, I don't have nothing in there. Better than that, you must come down because it's going to be opened. We're changing a location. I said, it's all right, my secretary, I'll give you written permission. She can open it. If you find $1 million in there, you tell me or what, because I don't recall. No, you have to come yourself. And then the next thing comes, $19,000 to pay for the opening of the box. This is 30-odd years. And I'm linking this to what can happen with the Integrity Commission. So, of course, you turn up down there. I said, no, I can't. I've come in and can't come. I said, listen, open it. And I said, you have my written thing. When they open it, of course, the box is empty. Never use it yet. Never remember I had it. Nothing at all. Now, when that happens with the Integrity Commission and you go before them and you say to them, I genuinely didn't remember this, but yes, I was incorrect. My information on the document was wrong. I do own this. I did have this box that I was using, and here it is. And they go through the various years, and what you say, the information was wrong. What really operates when on a basis of something like that that happens to persons? You are still charged because you forget. You have admitted, for some reason or the other, you just didn't remember that you had X. It happened long ago, and you have admitted it. You have indicated to them, and then you have some people turn in a report that, it says, add it to it, they accept it, and then you're still charged. And what happens there is that immediately those who wish to think ill of you, of course, they jump on it. And with social media these days, you destroy. So I am in full support of the Integrity Commission. I'm in full support of proper investigation. But I want to thank you because I think it's important that the nation understands that there are persons who serve in public life that have their names on documents that are tarnished, that really and truly there is no true basis for them to be, their reputations to be tarnished. So just want to say how important it is, your opening remarks and our approach that where there's wrongdoing, we must answer for it as public service. And whatever they do must be borne in mind that the idea is to have people in public service that are open and honest and not doing anything, but there is no requirement under the law to destroy someone's reputation at all.
Thank you, Member. Before we go to Member Chuck, just to refer to your comments, I want to draw the attention of the committee to Standing Order 77, subsection 3, that says, unless the House otherwise directs the Standing Orders Committee, and the House Committee shall not, but every other select committee of which we would be a part, shall have the power to send for persons, papers, and records. That power is within our remit so that we can assertively interrogate, which means though something may on the surface be before us, you can call and examine, not wantonly, not frivolously, but because it's reasonable, right, to note that the things before us may not be accurate or complete, and it doesn't have to be intentional either, but they can have an impact that is deleterious on the person that is the subject. For instance, what you said, Member Campbell, you will reasonably draw some conclusions, and I don't think there's any difficulty with that. But in my knowledge and understanding, particularly in legal practice, many times when a witness is before you, you get to understand that what you thought was the facts and the guardrails are not truly that. So we have that authority to interrogate, and that interrogation will either help to strengthen the case or, through scrutiny, help to protect someone that is innocent. The other thing, Member, is I want to draw the attention of the committee to the Integrity Act Commission 2017, Section 5, subsection 4, where the Integrity Commission, the commission shall, that's how it starts, and for the benefit of the public, the commission in the definition section of the Act is and means the Integrity Commission established through the Act, shall A, subject to sections 34 subsection 3 and section 36 subsection 4, be ultimately responsible and accountable to Parliament, not for some matters, but but for all matters relating to the function of the commissioner. And it's subject to Parliament through us, primarily. And B, it monitors and reports to Parliament again on the operation and effectiveness of the provisions of this Act. Member Chuck?
Chairman, I would hope you give me a little leeway to mention a number of operational matters which I want to bring to the IC commissioners and directors in terms of how they go about their work. And I bear in mind what Member Dalrymple Filbert has said. In recent times, the IC, well, let me say, I've been almost 29 years in Parliament, and I've submitted about 34 statutory declarations. But in recent times, the IC have asked me a question: what improvement have I made to my home? And the cost of the improvement. I mean, I find that intrusive. No, I don't have a problem if they say, have you done any structural improvement, or you have had improvement exceeding 5 million or 10 million, as the case may be. But when you're asked, what improvement have you done to your home, and the cost of the improvement, I think this is persecutorial than anything else. So my response was very simple. I have not seen any improvement to the structure. But my wife has done a lot of gardening and has doubled the number of orchids that we have on the property. I mean, you know, what more can I say?
Did they go on to ask you how you were able to double the number of orchids in your garden?
With due respect, and I asked the IC to comment on that when they come here. Is it appropriate to ask what improvement have you done to your home and the cost? No, it would be useful to say, have you improved your property or any property to the tune of 10 million or more, or 5 million or more, and so how did you, come by that funds? But I was worried, Chairman, because I had to ask my wife, did we paint anywhere last? No, because you might paint the house and it costs 2 million. And if you fail to say yes, I could be in trouble. Fortunately, to the best of my wife and my knowledge, no significant improvement had been done to the property. Then, Chairman, it might be useful for us to ask other parliamentarians if they have questions of the IC to bring it to our attention on both sides. Because they have gone to a process now, Chairman, where they, especially new members, they're asking persons, what did you own? Ask about property that they owned before they became members of Parliament. So you have situations where members came into Parliament in 2020, 2025, and they have been asked, your property, at this, we notice you have a property that you purchased in 1970. When it turned out that property was in somebody's name, similar name, but it's somebody's different name. I mean, you waste the time of a person to respond to questions about property that you purchased before you became a member of Parliament. And I think, Chairman, that the IC should not be investigating and asking questions about property that you own before you became a member of Parliament. So there was a colleague of mine who was asked what happened to the vehicle that you had in 1991, because it shows that he still has the certificate. And the member responded, it has been lying at my house deteriorating. In other words, another point, Chairman, they asked me about 2 companies that my name appeared on. Truth at the matter, those 2 companies were formed in the late 80s, never operated. My response to them, I know nothing about the company, which was wrong.
Right.
which was wrong. I said, I know nothing about these two companies until they pulled the registration of the companies, sent it to me, and I said, yes. Those were two companies. When I was an attorney practicing, we formed several companies, but these two companies never operated. And it put me through the expense of having to take these two companies and then close them at the Register of Companies. So what I'm saying, Chairman, I don't know to what extent it is appropriate for the IC to be asking questions of members of Parliament about properties that they owned before they became members of Parliament. I have seen and I have heard from colleagues on this side, and I'm sure it happens on your side, where the IC may be asking them about a car they're purchasing 20 years ago, and how much did you purchase it for? And you sold it in 2009, how much did you sell it for? These are things which, with due respect, Chairman, if I was the person, I wouldn't remember. I wouldn't remember who I sold it to or what I bought it for. And I think it is unfair that the IC should be doing this to members of Parliament, because it is happening. They're not complaining. But when you talk to them, they say, but this is intrusive. And we need to ask the IC what is appropriate for you to be asking for members of Parliament, anyone, about matters which they would not even, if they search their memory, they search their files, they wouldn't remember, right? When 7 years have passed, Chairman, they should not be asking for details. That's my view. And I think we need to get the IC to set it clear that there must be a time frame. I mean, I think a colleague of mine said that they should not go beyond 2018. Anything before 2018, when the act was passed, they should not be asking questions about it. So, Chairman, I am concerned because a lot of my colleagues are being put to extreme expenses trying to get time and inconvenience, trying to get information for the IC. And we need the IC to do better, because members feel, and that is why members feel that they're being persecuted. Again, it is possible, Chairman, that when the IC comes with the electronic, and we hope it will be this year, I don't have any problem everybody filing statutory returns. But I have visited the IC when it was the corruption proceedings, Chairman, when I, about 12 years ago, and they had an office similar to where the Integrity Commission is now. They have a room full, bigger than Parliament, of statutory returns. It's not possible for them to investigate. Every year they get 30,000 statutory declarations. It's just not possible for them to investigate all of this. Now, we did, in the last fiscal year, move the persons to file statutory returns from 5 to 12 million, I think it is. In other words, no one can file statutory return. No one needs to file statutory return unless they're earning, I think, over 12 million. But still, Chairman, I think we're wasting time. Even if 12 million are returned electronically or paper, you're still looking at 15, 20,000, members of the public bureaucracy. And I think IC need to guide us if that makes sense. I have no problem saying all politicians, all councillors, all MPs, all senators must file returns. No problem. But I think it is unfair to members of the civil service. All these civil servants here earning good money. Every year you have to file statutory returns. I mean, for what? I just feel we need to, for the IC chairman to succeed, they need to focus properly on allegations maybe, or where they get complaints or they feel that a person or persons or a department have benefited enormously, and you do those investigations. But you cannot go on net fishing and hope to catch somebody. You need to do more spearfishing. Check out who you want to spearfish. So, Chairman, I want this IC to succeed, but the way it is going about it is not, it's going to damage people's reputation more than succeeding.
Thank you, Member. Member Marks.
Thank you, Mr. Chairman. Just wanted to support what Member Chuck said and ask, and just to share that I did have a conversation with the IC persons when I just came in and trying to understand the process. And I pointed out some of these things because there are too many things that are discretionary, not material enough for us to be spending so much money and time. And they said, that's your job. The Parliament created this act and it's your job to change it, which is why I asked earlier, what do we do in this committee in terms of moving in that direction? So I think when we hear these recommendations, I'd like to know that there's a channel that we move from speaking about it and that it is channeled into the other joint select and that we put it all together as part of the reform process. So we're not just talking in a vacuum. Thank you, Mr. Chair.
I just wanted to respond to Member Chuck's last set of comments in relation to the way the ICE operates. I don't know if it was this committee or the Joint Select Committee, but maybe 2 or 3 years ago they were here and they went through a very detailed review of the statutory deductions, the statutory declarations. In addition to moving the threshold to 12 million, they adopt a risk-based approach where they determine the categories of persons whom they would require to provide the statutory declarations. And they did so because of the reason Member Chuck raised. It was physically impossible to analyze and assess properly the thousands of declarations that have come in. And they have also indicated that once the electronic declaration system is implemented, they'll be able to use AI technology to assist in doing some of the analysis. So I'm just saying to be fair to them, they have done a review to reduce the amount of persons who are declaring, and they have also, they're moving to a system which would make it easier once the electronic system is in place to do the assessment. So I don't think it is as broad as Member Chuck has said. That may have been the case maybe 5 years ago, but certainly moving it from 3 to 12 million eliminated a number of categories, and also the risk-based approach in terms of the categories of persons who would be required has also narrowed it down to persons who are in areas where they may be issuing procurement, permits, those kinds of things where there's obviously a risk of, corruption.
Thank you, Member. And further to your comments, Member Robinson, that perhaps it would be useful to all of us for the clerk or the relevant support member to provide this committee with some details of those changes in operation of the IC from what used to be the conduct in the past and what exactly it is that follows now in terms of any amendments to how they approach these issues, the increase from 3 to 12 and other things. That would be useful, I believe, to all members. Also following up on the remarks of Member Marks and Chuck, I believe that's why we are here. And as Member Marks has reiterated, the reality is that we have the responsibility now of requesting explanations from the Commission, of conducting the relevant hearings, of obtaining legal opinions as required, reporting that to the Parliament, ensuring that the necessary changes, whether legislative or otherwise, are implemented, not just to change the IC, but to improve it. And I believe that as a committee, we have to make it clear to the country, because I'm telling you, when people hear, Member Marks, that we're changing it, there is a suspicion to many. And we have to make it clear that this Oversight Committee is improving the IC, strengthening the IC, enhancing the IC, protecting the people of Jamaica, and whatever change it is that we would recommend is a change for the better. That said, we are now at 8. Or was that 8? Oh, not yet? Your mics are for 8? Any other business? I'm not sure which one was first. But
okay, thank you very much, Mr. Chair. Thank you very much, Member Samuda. So I dealt with the issue of the failure to file because that arose in the review of the reports before us. But in relation to some of the comments that you had made earlier, I'm using the opportunity to deal with the changes that we suggest. I believe that we also need to make it clear that and I think Member Chuck alluded to that as members of Parliament, as ministers, we know that we should be held to a higher standard, and that by virtue of volunteering for these positions, we are expecting to be held to a higher standard. And I say that because that then has some implications for how we behave, one in relation to our interaction with the Integrity Commission in terms of the information that they request of us. So failure to provide information by members of Parliament, by ministers, I think is something that we really should look at carefully and deeply for those of us who understand that we have to lead by example. I also want to say that suspicion is understandable by the public when we are suggesting changes because of how we also, as members of Parliament, have behaved towards the IC. I go back again to the findings of the AC that indicate administrative and management weaknesses of the institutions. It also points out, I think, a responsibility from government that I believe, in as much as we talk about what we want to see in terms of changes from the IC, we also need to require those changes from government, whether it is ministers or whether these are institutions, about how they acquit their responsibilities. When I see the IC make a recommendation about training, for example, in certain areas, I'm not even sure what is the word that I need to use, because that shouldn't be coming from the IC, because that points to a significant weakness in the institution that they are examining. And I find that there are too many where their recommendation to deal with the issues end up being training, end up being further investigation by the same institution about the recourse that they can take to either recover funds spent by the institution. And I really believe that in as much as we need to hold the IC to account, we need to hold government to account, we need to hold government institutions to account, and that has to be a significant part of what we do as well, because we sometimes, by virtue of our own pronouncements, give the IC a bad rep, when in fact the failure is actually on the part of government or the institutions under review.
Thank you, Member. Member Samuda.
Thank you, Chair. Two matters for your and colleagues' consideration. One, Section 64 enables regulations to be created for the procedures related to filings of the members of the Integrity Commission, certainly members of staff and commissioners themselves. Those regulations don't yet exist, and the inherent conflict identified by both the Joint Select Committee and the previous Oversight Committee of members of staff declaring to themselves and examining themselves has not yet been addressed. And I think the first recommendation that this, not first, but obviously there have been points raised today, but certainly one of the issues that should be forwarded to the attention of the Joint Select Committee for Legislative Change should be, to my mind, that this group of individuals should have their evaluation or their review done by an external body, whether the FID or Auditor General, if the Auditor General doesn't remain on the commissioners. That has been a source of much discussion, but certainly you can't review yourself. The other request I have would be for any research done or available, or if it hasn't been done, that it be done on what the appropriate arrangements are for oversight committees of similar commissions within similar jurisprudence. Meaning you are providing oversight to someone who is providing oversight to you, of you. It's an odd arrangement, certainly feels that way to me, and that has given rise, I think, to members on both sides not wanting to serve on this particular committee. That has given rise to comments made in the past of fear of victimization, whether real or imagined. And I think any research that exists on, or any context that exists, or any best practices in other jurisdictions would be useful for this committee to contemplate. Similarly, should we be declaring to the FID, which has the capacity to examine as they do fit and proper for persons in the financial industry or for attorneys. It's a thought, and I think it is worthy of examination here for a recommendation to go whether to continue as is, to strengthen, to totally change. Us being on the Oversight Committee, we'd all know how we feel about the particular issue and how you feel about the oversight that you're being asked to provide. I think those matters need to, during our tenure, be examined. And with that, a consideration also is, should the committee, as is, continue to be a special select committee, as the standing orders give rise to, or should it include all parliamentarians as a special joint select committee, considering that the oversight affects those members as well? So just points for your consideration, colleagues, through you, Chair. But I believe, and the request is on the floor, for any research that exists, and if none exists, for greater, or for some research to be done to guide us in terms of what exists in other jurisdictions. Because if you're providing oversight, your files should probably go through the Director of Information to be reviewed at FID, not at the same entity that you're providing oversight for. Just a contemplation.
Critical matters, member, I can confirm that the Joint Select Committee had started the deliberations on that issue relating to whether the person responsible for reviewing should then be reviewing themselves in terms of the compliance issues for that. So that's a matter that we could ask to have reiterated at the Joint Select Committee level, and whatever issues we would want to put forward or advance, we can do so to strengthen their examination of that point. I wanted to just go back to Member Brown-Burke. Okay, you raised a very interesting an important issue in relation to declarants and what our responsibility as an oversight committee would be to examine, or in relation to the issue of the responsibility of a declarant. Perhaps it's a matter that we can be guided on, and I'd ask for counsel's view, but in my estimation, the Oversight Committee does not have the authority to dive into the declarant's activity in that regard. We, however, can encourage. We, however, can speak to whether or not the activity of a declarant is affecting the Commission's ability to effect its mandate. But just for those listening, it would be very important to distinguish between the two. Our responsibility to hold the Commission to account as to what procedures it implements in gathering information and how it operates and functions in terms of the different systems used to gather, and how it operates in terms of how it ultimately determines whether somebody is found to be in illicit enrichment or whatever other charge. That's the remit within which we operate. But otherwise, we'd have to be encouraging, because we would not have the responsibility, I believe, to see it to a declarant. You did not do so, and therefore it's a problem. I just want to be clear on that. Otherwise, for the other comments that were made by colleagues, I think it's very important, and where necessary, I'd ask the clerk, council, and the support teams to make sure that the relevant issues are put into a written construct and to be delivered to the Joint Select Committee once that is up and running, and otherwise that the comments are noted, not just in minutes, but in a form that would assist members in terms of our preparation for the next meeting when the IC and other relevant officers will be here. It will assist us in terms of the conduct of our examination and whatever other information we seek to elicit. All right?
I seek your indulgence, Mr. Chair. One, because you did comment on a matter that I said, and I wanted to make sure that there is absolutely no misunderstanding. And also because when I spoke then, I had forgotten to include, in response to your opening remarks and the principles that you spoke about that should guide us, that there were some principles that I thought should also guide Parliament in terms of how Parliament dealt with the reports that came before it, and therefore those that came before us as a committee. And I wanted to also broaden your principle of fairness and your principle of timeliness to the actions of the Parliament that allows us as a committee to do our work as well. That, because I thought that it was needed, that there should be no bias about what came before us, and that there should be also no preferential or bias in terms of the timeliness with which those matters came before us. But as it relates to what I had said about the act of the declarants, in as much as quite a few of the findings turn on declarants refusing to provide information. My major concern was about those of us who are part of this group and over which we also have responsibility, not necessarily as declarants, but as members of the Parliament, and the kind of behavior that we would expect. So that would come, I believe, Mr. Chair, in terms of what you had commented, that some of what would be said could be channeled to other committees within the Parliament that actually do have responsibility about the conduct of members of Parliament. And it was in that vein that I really had wanted to make the comments.
Thank you, Member. I think we have to be free to encourage. As a part of our responsibility, it's beyond just the remit of laser focus on the Commission. We're here to strengthen the nation's capacity to prevent and detect corruption. And as I said before, in terms of the substantive authority that we have, we examine the Commission's processes as distinct from re-investigating an individual declarant's affairs. But I agree with you. We must use the opportunity to inform, to encourage, to empower, to educate our colleagues and to educate the country. All right, that said, we're moving steadily ahead. The next matter for business, number 9, is the date of the next meeting. You don't have your diary before you, so you want us to...
Apart from that, I don't think we should be meeting unless we have a report.
Yeah, 64
or you mean to
reports.
consider this report?
64 reports are before you.
Well,
yes.
it's only the annual report because the other report might be sub judice, as you say. I'm not too sure we should be discussing it. Anyway,
It's many.
it's just that
All right, what we could do, with your leave, members, is we could adjourn for a date
to be fixed.
to be fixed.
Right.
And what I'll do is we use the next 48 hours to caucus amongst ourselves, as well as to work with the support team and to speak to the persons that we know for certain that we would want before us to determine what is the most appropriate date and time. All right, so we'll adjourn for a...
You said a person. I would think there should be more than one representative from the IC because you have different persons. Yes, thank you. Mm-hmm.
Well, whatever relevant person, authority, body,
yes.
entity
Yes.
that we would see fit. And I'd ask that within the period of time from this meeting to the next, that I be given the opportunity as chair to liaise, and if there is, for instance, someone other than that named by us in the meeting that will be called, that we not restrain ourselves, that we have the person before us, and perhaps we can caucus amongst ourselves to ensure that there's no difficulty or objection to that, as opposed to waiting for the next meeting for us to meet and then agree formally for that. Another issue, and this is just a matter in terms of administrative function, whether or not as a committee we want to integrate the option of having virtual meetings, just in case. Yeah. If there is no objection, then I'll have that noted in our minutes, and we'll set out what the terms and conditions in relation to virtual meetings would be, given the sensitive nature of this kind of meeting. Hybrid, all right. So that said, we move on to item 10, closing remarks. I have another 20 pages here that I want to... I think I will just to say we're looking forward to doing some work on behalf of the country. I want to thank members for your active participation. I believe that we will be able at the end of this process to all look back and say that we have strengthened the Integrity Commission in whatever the form it is at that time. Thank you, members. Thank you to all of the support team, the clerk and others who continue to work. We have a lot of work to do between now and the next meeting, and we're committed to getting that done. That said, we'll ask that we adjourn the meeting. Is there anyone who... All right, adjourned by Minister Marks and seconded by Member Brown Burke. That's it. Thank you very much, members.